Don't let your final farewell stir up family feuds. Welcome to Before You Go, a podcast brought to you by Texas Estate, Trust, and Guardianship attorneys, Stacy Kelly and Keith Morris. Preserve your hard-earned legacy. Be in the know.
Keith Morris and Stacy Kelly, and today we are here with the Before You Go podcast. Today our topic is appellate law in Texas, is another legal topic that surprisingly people want to know something about because there are a lot of myths about what an appeal means, how long it takes, what you can and can't do, whether you have a jury or not, what the judicial structure is. And, I'm going to be honest with you, this is not something that I do often. In fact, I leave it to smarter people like Stacy to deal with appeals because this is something that she has done. And so today we're going to talk about Texas appellate law, and I'm going to let Stacy take it away, tell you a little bit about her appellate experience, and then we'll go through the process.
Thanks. I got started doing some appeals in the first year that I was a licensed lawyer. Someone came into the firm and said that their parents were divorced. The father had been given all of his life insurance and all of his 401ks, and the mother was, she no longer had any access to those. However, when he died, he was working for DuPont, and DuPont said, no, we're paying the ex-wife, period. So they came to us. We looked at the law a little bit and realized that we thought we had a pretty darn good case. And they wanted us to take it on contingency, which the partners were not really excited about, but they decided, let's let Stacy cut her teeth a little bit and we'll let her handle this and we'll watch over. So that started in 2000. We got to the United States Supreme Court in 2008. So it took 8 years to get there, but we won all the way up until the Supreme Court, and then we lost. And we can discuss that at another time.
We're not supposed to talk about cases where you lose.
I know. But the client still made out like a bandit because mother got everything, and then mother died in a drunken stupor. And so client already had all the money years before we went to the Supreme Court. So it was just an exercise to see what would happen.
So let me ask you a question really quick about that. Was the 8 year period, and this is something that happens all the time, people have very unrealistic expectations about the length and breadth of how long an appeal takes. The 8 years from to the Supreme Court, was that beginning with like you guys filed suit, or did that start with when you did the first appeal?
No, it started in 2000 when we filed breach of contract action, and she was entitled to this money. And the district court said, yes, you are entitled to it. DuPont appealed to the Fifth Circuit. That took time. You've got to write briefs and get ready. We had oral arguments before the Fifth Circuit, and we won in the Fifth Circuit. And then we did a writ to the United States Supreme Court, or DuPont did, and the court granted it. And then the court tells you to brief things, and those briefings take so long to do. And then it was 2008, October 2008, when we had the oral arguments before the Supreme Court. So it's just the progress of litigation and how long it takes. And we can get into that later. Since then, I've done dozens of appeals, many in probate, some not. The big question is, what can you appeal? You can't just appeal something because you didn't like the results. You have to have what's called reversible error. And you have to have preserved that error in the trial court. So some trial lawyers don't know how to preserve error in the trial court, which makes it next to impossible for then you to hire an appellate lawyer, because that appellate lawyer has nothing to work with.
Yeah, I was going to say, give a specific example or two of like what preserving error means.
Okay, let's say you wanted to get some evidence into the trial. You think it's relevant. You want this evidence in, and the court says, no, I'm not going to allow you to admit that evidence. If you just let it in there, then you have no grounds for appeal. What was the evidence? I have no idea. The appellate court doesn't redo the trial. The appellate court only looks at the documents that happened in the trial court. So you would want to do what's called a bill of review, which is, Your Honor, let me put on this evidence outside the jury so that if I appeal it, at least the evidence is before the appellate court. And so I do this bill of review. I put on all of my evidence. Trial continues the way it is. If I don't like the results, I think that by admitting that evidence, I would have won. Then at least the appellate court has something to look at. The appellate court goes, oh, yes, this evidence should have been admitted. And we are admitting it now. And now we're going to base our decision on that inadmissible evidence. That's one reason for how you preserve error in that type of situation. Jury. You don't like the way the jury was picked, that the judge was dismissing jurors that shouldn't be dismissed. There's a specific set of questions you need to ask and proffer to the court to preserve that error so that you can get it before the appellate court. There are interlocutory appeals. Obviously, any final judgment by a court gives you the ability to go to the appellate court. And you file it.
And that's sometimes very tricky, especially in probate. What is considered a final judgment and what is not, right?
Right, exactly. We have what's like you're doing an administration and you do an accounting and the judge rules that accounting, shouldn't have happened this way. Well, you can't appeal those final orders on that accounting because it did not dissolve every issue that there was before the court. It has to be a final issue that resolves that particular question or issue that you're trying. In Texas, there are certain orders that can be automatically appealed, even though the case may be going forward. Interlocutory appeals refers to an appeal from a court order that is made before the final judgment in a case. They're like if a court appoints a receiver or appoints a trustee, that can be appealed. And those are found in the Texas Civil Practice and Remedies Code. If a court grants or refuses to grant a temporary injunction, those can be appealed right away. So there's a long list in section 51.014 of the Texas Civil Practice and Remedies Code that tell you all the things that can be appealed.
And we learned the hard way in the Lewis case, right, that sometimes there are things that can be permissively appealed. And even if the court rules that says on the record, essentially they're going to make a ruling for the specific purpose of everybody being able to take it up on appeal and both parties agree that the issue needs to be appealed, the appellate court can still say, nah, we don't think it's ripe yet, right?
Right. The appellate court makes that final decision. A lot of times they ask for a short briefing on why you think you have the right to appeal. I see that a lot in appeals. When there's a question over whether you can appeal it or not, they'll ask for short briefing. They'll tell you a couple page letter, just tell us why you think you can appeal this. One misconception is that an appeal is basically retrying the case, and that is not the situation. The appellate courts are not finders of fact. They are finders of what the law is. So, you can't put forth new evidence before the appellate court with an exception, and I'll get to that in a little bit. You can't put on new evidence. The court only has all the orders, all the discovery, all the motions, all the briefing that happened in the court below. That's all they can make their decision on. So again, it's important that you preserve your error down below. Now, introducing new evidence, I talked about that before in the Bill of Review. And while the court may not have considered that evidence, the appellate court can if you preserve it with a Bill of Review.
I'm asking this question, and I don't know the answer. That's why you're here. You're the expert. But let's say hypothetically that you have that piece of evidence that you feel like was important, but it requires testimony. When you do your Bill of Review period outside the presence of the jury, do you have the court allow you to question a witness or two with that document, or does the document have to just stand on its own? Or when you do the briefing, do you explain, the court refused to admit the, damning letter that said that so and so stole the money, and I didn't question any witnesses, but here's the significance of this document. Like, how do you handle that?
Well, if at all possible, I would definitely put someone on the stand to authenticate a document, if it's a document that I'm trying, it may just be someone's testimony that I'm trying to get in, and the court says it's not relevant. So I would put that person on the stand. They make the decision that's, too prejudicial or something to that effect. And I put that person on the stand and I go ahead and solicit, you know, answers from them. And that transcript of that can go up to the appellate court if I'm arguing, lack of evidence or something to that effect.
So you're saying it's not an opportunity to retry the case. The appellate courts are finders and interpreters of what the law is based on the facts, but there are no new facts or evidence that are introduced, correct?
Correct. For instance, I've seen people want to appeal a guardianship decision where a court appoints a certain person as someone's guardian and the people don't like that and they want to take it up on appeal. Well, if it's just the facts, the appellate court is not going to redo the job of the trial court. They are not in place to determine whether someone is an honest witness or not. That's for the finder of fact to decide, and that's the jury, or in a bench trial, it's the judge. Appellate courts are not going to review that for sufficiency. They're going to rely on the people that heard the testimony, who saw the witnesses, who can judge their credibility better than anyone. Appellate courts don't think that they can do that, and they can't. They weren't there. So what an appellate court is doing is determining whether there was an abuse of the law below or should have happened differently, and under the law, should this be retried or should we give an opinion right now? For instance, I had a case where the judge here in Houston, husband and wife are married, wife dies. Years later, the husband dies and they're probating his will. And he leaves assets to his nieces and nephews. Well, he didn't have any nieces and nephews. He had his wife's nieces and nephews. But once they were no longer married, they were not his nieces and nephews. And so we argued that to the judge, and the judge said, no, I'm going to go ahead and give it to him. That's what he understood it to be. And we took him up on appeal, and the appellate court agreed with us and said, no, after the death, those were not his nieces and nephews. Now, just because you have an appellate order doesn't mean anything. I walked back into court with my chest all puffed out because I had won, and now you have to do it this way. And the judge said, I'm still not doing it that way. Take me back up. So, you got to pick your battles at that point.
And there are some times where, I remember specifically a case that Jason and I had where there were a whole bunch of summary judgments filed in different motions that, depending on the order in which they were granted and this, that, and the other, that it would be a final disposition of the case. And the judge essentially told us, this is complicated. I'm just a country judge. I'm gonna just make the best decision I can, and then you guys can let the appellate court sort it out, right? I mean, that happens too.
Oh, it happens a lot. Yeah. There is what's called a mandamus. And that's not necessarily, it's the judge has done something that you don't believe can be corrected on appeal. Okay. So the judge has made a decision now. And if you continue along this route, then it is detrimental to one of the parties. And by the time we get to an appeal, you can't correct it, appellate court. It needs to be corrected right now, what the judge is doing. And that's called a mandamus. If you're going to mandamus a judge, I'd be damn sure you're going to win because you're still in that judge's court. Okay. You may mandamus, but you're still in that court till final judgment. So yeah, be very careful when doing that. Or if you already have a bad relationship with the judge in that case, then I guess it doesn't matter, but it's something to look at.
And so before we kind of get into specifics about appellate law and, probate and will contests, could you just give us sort of the run through? Okay, so you file your case and then this happens and then that happens. Like, give us the A to Z on the appellate process. And also one thing that we wanted to clarify, of course, was that When the appellate court looks at stuff, it's a panel of judges, and I'll let you talk about that more specifically, but it's not a jury, and the jury is no longer involved, right?
Correct. Okay, let's say you try a case, you get to the end, you have a final judgment, the jury has come back with their opinion, you get a final judgment, the judge signs it. You can do a motion for retrial, asking the judge to redo it because of some error that you think happened. That gets you 15 more days, but otherwise you have 30 days to go to the appellate court. So you have to file a notice of appeal within 30 days of the final judgment. And that's filed in the trial court as well as the Court of Appeals. And then the Court of Appeals you have to gather the record. There's the court reporter's record, which is all the testimony that was given, any transcripts from any hearings that you want in there. There's also the document portion of it with any motions or, responses that you want. So you really need to take a long time to look at the docket to determine exactly what you want to be the record on appeal. There's a reporter's record and then the court reporter's record. I did one time in an appellate case, did not get one piece of evidence over to the appellate court. Thought I had not. That can be detrimental. At least we saved the day on that one. But so you get the record all together. The people on the other side from you on the appeal have a right to put more documents into the record if they want, if they feel like you didn't put the proper things in. And eventually there is a deadline that the appellate court sets. It's never really followed too closely because clerks and court reporters don't always get their records there on time. But eventually there is a record, and that's the record that you have. And they're numbered differently each page so that you know what it is. And then the court will give you a deadline to file your briefing. I will tell you the way the appellate courts in Texas work, that deadline is never really solid. You can always ask for more extensions. I had one where I'd asked for the third, I was on the third extension. And the court says no more extensions unless you can show, terrible things. And I still got another extension after that. So the appellate courts are very leery to have appeals decided on technicalities. They want it decided on the briefing. But basically, you do your brief, then the other side has 30 days to do their brief. You can file a response to their brief. They can file a reply to it. Eventually, all your briefing is in the appellate court, and then you either do or don't have oral arguments before the appellate court. There are less and less oral arguments these days. The courts just, I don't know, unless it's something really technical that they're having a hard time getting their head around and they want to talk to the lawyers about it. But more likely than not, they can make a decision based off just the briefing. And so oral arguments aren't usually heard. When they grant their decision, there is absolutely no law, statute, or anything that tells them when they have to rule. I have seen appellate courts come down in a couple of months with a ruling, and I've seen them taken way over a year and a half to issue a ruling. So you're just at the mercy of the appellate court at that point. Then you get the opinion. And now the opinion could be reversing the trial court and entering in a new judgment, or they could remand it back to the trial court and say, we want more information, or trial court, you should have considered this. So we're sending it back to you, and now you have to consider this and then make your ruling. So.
Interesting. And so things we've learned thus far, one, it's hyper technical. Two, it's going to require a lot of writing and making sure that you cross T's and dot I's, especially for the trial attorney, to make sure that they are doing the things they need to do so that they raise issues that can be appealed. You need to know under what circumstances you can, use an interlocutory appeal or a permissive appeal, or at what point things are considered final, right? Those are all important considerations for trial attorneys and just the general public. People go and they hire their lawyer and they go to trial, and then something happens, and then they're like, oh, I want to appeal that. And they may not have the ability. It's just they've seen TV, and so they think that they just have an automatic right to appeal whatever happens, that, it's nothing's ever final. That's not always necessarily the case. if there's not an appealable issue, then that case is final at the trial court, period, end of story, right?
Right, correct. I mean, you have to
Um,
have something to that the appellate court has to rule on.
right.
And you have to give
Uh,
them something.
And so, the way that we sort of weave these into our probate cases is that some of the common ways that we can test wills are, capacity, undue influence, improper execution, things of that nature. Those are all things that can be appealed based on, whether or not evidence was admitted to either prove or disprove the capacity or the undue influence or the improper execution or things like that, right? I mean, talk about maybe a case or two that was a probate case that you appealed and sort of what the basis was.
Okay, we had one will contest where this was up in Montgomery County, and the judge did not allow us to put on a particular witness, thought the witness was too biased and it would be too prejudicial for the jury to hear. So I did a bill of review in that particular one and put the witness on the stand and did the background and built the foundation and felt like we had rehabilitated the witness, that it wasn't prejudicial and that it was something that the jury should have had an opportunity to consider. And so we lost that will contest. And so we appealed it on the grounds of new evidence, or, you know, our inability to put that evidence on. And the appellate court looked at it and remanded it back for a new trial. Now, I will tell you, I haven't seen too many cases where there actually is a retrial. Okay, because people have spent all the money on the trial. Now you've spent all the money on an appeal, which is 15, 20,000 per side. I mean, it gets expensive. And you've spent all that money. Now the appellate court says, we're sending it back. We want a new trial. And this time you need to let that evidence be put on. Well, who has another 50,000 to redo a trial at that point? So many times when it's remanded like that for a new trial, the parties will settle. They kind of, we tipped our, put our toes in the appellate court for just a little bit. Now we kind of know what they're going to say. And the fact that they ruled this way gives us a better ground to settle the matter.
And so it's a good way, even if you're not going to go back and get a retrial, it's a good way to position a case so that it can be settled because you have probably more than enough information at this point to determine what's going to happen next in the event you retry it. Allow that evidence. That evidence is heard, and then it goes back to the appellate court in the event something else happens, right?
Right. I had a case in front of Judge Wood, and I filed a motion for summary judgment on the issue of a will not being a valid will. And it was the validity of the will. So it was a question of law, not fact. It was whether the will was valid. And Judge Wood denied the motion for summary judgment. So we went to trial and we put on all of our evidence, asked for a directed verdict. He denied the directed verdict. Went through the second half of the trial. The jury ruled against us. Asked the judge for a judgment notwithstanding the jury, which is asking the judge to say, jury got it wrong, and this is my ruling. And he granted that. And he said, the jury did get it wrong. I should have granted your motion for summary judgment. I should have granted your directed verdict, but I really wanted them to have a chance to get in front of a jury, and I expected the jury to do the right thing, and they didn't. So we took that up on appeal and won the appeal on that one.
So this has been another sort of topic that, it's a little bit, it's the great thing about probate and estate planning and trust work and guardianship work that we do is that it touches so many ancillary things, right? I mean, it touches bankruptcy, it touches personal injury, it touches family law, it touches all these other things. So it gives us the opportunity to, especially in this forum, to give a broader education to people about different topics. But appellate law affects everybody. And since we are trial lawyers and you are an appellate lawyer, this is something that other lawyers and the public can benefit from because they may not necessarily understand from watching television how that works. So I feel like we've done a good job today of explaining this, and there's going to be more in the future because there are some other sort of deep dive issues that you can get into, but this is a good overview. So were there any final words before we sign off for today?
just for people to understand that just because you're an exceptional trial lawyer doesn't make you an appellate lawyer. And also for the trial lawyers out there. You know, if you're a probate litigator and this is what you do all the time and you need an appellate lawyer, it's probably a good idea to get an appellate lawyer, not try to work your way through the appellate system. It's too many ways to get, in the weeds, get in, miss deadlines, those type of things. So it's important for people, if you're going to appeal a decision, to have at least one of the lawyers on that team have done several appeals. I've done dozens of appeals, Fifth Circuit, United States Supreme Court. So I feel pretty confident in what I'm doing, but it all boils down to, do you have an appealable issue?
And I do consider myself an exceptional trial lawyer, but I have no business whatsoever doing any appeals. Well, that's fantastic. So again, we thank everybody for listening. I want to thank Stacy for taking the time out to talk through this topic. We hope people aren't dissuaded, because sometimes people consider this to be sort of a murky topic, but it's not. I mean, it's something that's practical. It's important. People need to know how it works. And again, since this is a podcast about things that you need to know before you go, you do need to know about appeals. And so I will thank you again to Stacy, and thank you to the audience. We're out for today. Thank you.
Thank you.
Now, before you go, learn more about how Stacy and Keith can help protect you by calling or visiting us on the web. Links to our website and phone number are in the show notes. The information on this podcast is for general information purposes only. Nothing on this podcast should be taken as legal advice for any individual case or situation. This information is not intended to create, and receipt, viewing, or listening does not constitute an attorney-client relationship.